Okay, so good evening, Edward, Amelia, and Vivian. We're now in week 3, and tonight we will be talking about merit review and administrative tribunals. Before we start talking about this tonight's topic, would there be anything you wish to ask or clarify? Perhaps in relation to other topics we've previously covered, or something that you came across, or it might be in relation to the assessment. Would there be anything else that you may want to say before we start dealing with the tutorial questions tonight? None? Okay. I mean, feel free. I've muted everyone, so if you want to say something, you have to unmute yourself. There are only 3 of us, which is quite good because that's the sense of intimacy. It's a very closed group discussion that we have. Okay, but this is going to be recorded for the benefit of those who have been unable to join tonight's session. So tonight, in terms of key outcomes, after this session, you should be able to discuss the essential characteristics of merits review, the jurisdiction of the Administrative Appeals Tribunal, and the scope of Administrative Appeals Tribunal merits review. So let's begin by talking about discussion question 1. Can I have somebody read discussion question 1 for us? So we have about 4. We've got 4 discussion questions tonight. Can we have somebody among the 3 of you to read question 1 for us? Just to read it.
Okay, shall I read the first one?
Thank you, Edward.
Okay, the Financial Regulatory Agency, FRA, a federal regulatory agency that regulates the financial advisors industry, ruled that Mr. James Bull did not meet the professional experience requirement to be admitted as a registered financial advisor under the Financial Regulations Act. Mr. Bull sought to challenge the decision in an application for review to the Administrative Appeals Tribunal. The FRA objected to the jurisdiction of the AAT on the ground that the AAT had no power to rule on a matter that involved a legal interpretation of the Financial Regulations Act. Is this objection tenable?
Thank you, Edward. Would anyone care to offer an answer?
I think the AAT can consider issues of law, so the objection would not be tenable.
Okay. Thanks for that, Edward. My question, though, is that for those who've taken up constitutional law or are taking up constitutional law, it is actually for the courts to make determinations as to the law. And what we need to remember is that the Administrative Appeals Tribunal is not a Chapter 3 court. It is not a court. It is an administrative tribunal that belongs to the executive. So it could then be argued that for the AAT, which is an agency of the executive, to make a determination on the legal interpretation of the Financial Regulations Act Commonwealth would impinge on the separation of powers. How would you respond to such an argument? Or anyone? Can anyone respond to the point that I raised? So let me repeat the point here. So the Administrative Appeals Tribunal, as we know, belongs to the executive government. It is within the portfolio of the Attorney General, who belongs to the executive. And the situation we have in question 1 involves an attempt on the part of the AAT to make a legal interpretation of the Financial Regulations Act Commonwealth. The question then is, isn't the legal interpretation of a law, doesn't that involve the exercise of judicial power, which we know exclusively belongs to the courts, to the federal courts? And we will recall in one of the notes I put in Moodle that if you follow the ex parte Kirby or the Boilermakers case, the High Court ruled that it would be unconstitutional for judicial power to be vested in a non-Chapter 3 court. the Administrative Appeals Tribunal is definitely a non-Chapter 3 court. So that's my question there. For the AAT, which is a non-Chapter 3 court, to try to rule on a matter that involved a legal interpretation of the Financial Regulations Act Commonwealth, wouldn't that be a violation of the separation of powers and an encroachment into the judicial powers of federal courts?
Yes.
Again, go ahead.
Yes, actually, it's possible to argue in that direction because based on the doctrine of separation of powers, the courts are not conferred with non-judicial powers and vice versa. Yes, so the tribunals, it can be argued that the tribunals are not conferred with judicial powers. However, because of the characteristics of merit review, the merit review tribunals or the de novo reviews or the merit reviews, all these administrative, the AATs, their scope, they're giving a lot of prerogative. They're giving a lot of the scope of their duties is very wide. It can be very wide. So
the question that is being raised is that if it can be argued by the Administrative Appeal Tribunal that it has been vested by the Commonwealth Parliament under a law, under the Administrative Appeal Tribunal Act of 1975, that it has been vested by the Commonwealth Parliament the power to interpret a law. The question is, wouldn't that be an encroachment of the separation of powers and an encroachment on the exclusive powers of the federal courts to pass on legal questions? So that is really the question there. Is the Commonwealth Parliament in the first place permitted to do that, to vest the AAT with the power to interpret a law? Because that seems to go against what the High Court said in the Boilermakers case. What do you think?
Is it not relevant that it's an administrative decision which is being challenged, not the validity of the legislation itself?
Go on. That's right. So it's the administrative decision, but it is challenged on the basis of the fact that the administrative decision seems to be contrary to the proper legal interpretation of a law. So therefore, in relation to the AAT is required to interpret the Financial Regulations Act. So the question is that act of the AAT in trying to interpret the law, wouldn't that constitute an encroachment of into judicial powers and a violation of the clear prescription under the Boilermakers case?
Well, I mean, I don't know where the authority for this is from, but it definitely says in the notes that that the tribunals can consider questions of law as well as questions of fact.
Very good. So actually, you're correct, Edward. So if you follow the case of Collector of Customs, New South Wales versus Brian Lawler Automotive Proprietary Limited, the federal court pointed out that as far as administrative tribunals are concerned, they will obviously come across laws and will have to make an interpretation of the law in trying to review certain administrative decisions. Because as far as the merits review is concerned, it does look when a review of an administrative decision is made by the AAT, for example, it considers not just the facts, it considers policies, it uses discretion, but at the same time, it also has to consider the law because the administrative decision is something that has to be based on an enactment. So necessarily, therefore, any administrative decision will to an extent involve the interpretation of a law. The fact alone that there is a process which involves the interpretation of a law does not mean that the administrative tribunal necessarily is ousted of its jurisdiction. The clear limitation, though, is that any attempt on the part of the administrative tribunal or the AAT to interpret the law is not really binding. It does not even set a judicial precedent, and neither is it conclusive as to what the proper legal interpretation is concerned. But for the purpose of a review by the AAT of a particular administrative decision, it is definitely within the power of the AAT to determine if the administrative decision was done in accordance with the law and in the process that involves legal interpretation. But the mere fact alone that there is a process involving the interpretation of a law does not mean that the administrative tribunal is therefore divested or ousted of its jurisdiction to review an administrative decision.
Sorry, what was that case that you mentioned? Which
that's going to be Collector of Customs of New South Wales versus Brian Lawlor Automotive Proprietary Limited, which is a federal court case. So Collector of Customs New South Wales versus Brian Lawlor Automotive.
Okay, is that referred to in the notes?
It should, I think it should be in the notes. Yes, it should be in the notes. So that is a very crucial, a very crucial principle that we need to remember in administrative law, because it will keep on cropping up in this course, whether or not administrative tribunals are actually permitted to interpret laws. Because because an administrative decision, for it to fall within the purview of the jurisdiction, to fall within the jurisdiction of the AAT, it is necessary that the administrative decision must be based on an enactment. And so therefore, it necessarily follows that any review of an administrative decision is most likely to involve an examination of what the law provides. So the mere fact that the AAT may engage in the process of trying to interpret the law does not mean that the AAT then loses its jurisdiction over a review of an administrative decision. It is just crucial, however, to point out that any legal determination made by the AAT is not binding, and neither is it determinative or conclusive of how a court, of how a law should be interpreted. Any questions? Okay, I got that, Vivian, that you've got a problem with your computer. Okay. So moving on. No questions? Okay, thank you. So thank you, Edward, Amelia, and Thea, and Vivian for joining tonight's session. I just wanted to say that because otherwise it would have been more lonely if there were only 2 or 3 students tonight. So at least there are 4 of you, which is good. Okay, discussion question 2. I'm just going to read this because this is quick. In a case before it, the AAT considered evidence and matters that were not before the decision maker. Party X, who was one of the parties to the case before the original decision maker, argues that the AAT went beyond its powers in considering evidence and matters that were not before the original decision maker. Is the argument of X correct?
The tribunal can consider new evidence as well.
Mm-hmm. So even if they were not brought before the original decision maker?
Yes.
So, but wouldn't that kind of, well, at some point we're going to be talking about the rules of natural justice, which means, you know, the right to be heard. But wouldn't that be kind of a violation of the rules of natural justice, where evidence is suddenly presented before the tribunal, something that was never taken up or raised before the original decision maker, and then the tribunal makes a determination on the basis of new evidence? What do you think? Wouldn't that be kind of violate the notions of due process and the notions of natural justice?
Well, I think as long as the new evidence is valid, then I don't see why that would be a problem.
Very good. So as we will know later on, the the principle of natural justice is mainly based on the common law. So the right, for example, to be heard before a decision is made against a person is a common law principle, meaning it is a principle recognized by the courts. However, what it also means is that if it is a common law principle, then that common law principle can actually be changed by the Commonwealth Parliament if it passes a law that limits certain common law principles, or it can even, or the Commonwealth Parliament may even decide to do away with certain common law principles, such as the right to natural justice. In this particular case, while it may be argued that the raising of or the admission of evidence for the first time before the AAT may seem to violate the notions of natural justice, because that evidence would have been considered before the original decision maker, it is very clear that under the clear statutory provisions of the Administrative Appeals Tribunal Act of 1975 Commonwealth, the Commonwealth Parliament has said that the AAT has the power to consider evidence de novo, and as if it were standing in the shoes of the original decision maker. And so therefore the AAT has the power to consider evidence and matters that were never brought before the original decision maker. So Edward, you are correct. Okay, questions? Okay, question 3. Can I have somebody to read or go over question 3 for us? Vivian, yes?
Yes.
Thank
Okay.
you.
Yeah, you're welcome. Students protested against the visit of the Chinese Defense Minister to the Australian Parliament in February. When the student protest went out of control, student Josh MacArthur suffered injuries after he was shoved to the ground and kicked by a member of the Australian Federal Police. He filed a complaint to the Commissioner of Police against the police officer who caused his injuries. After an investigation, the Commissioner of Police made a finding that the police officer involved in the incident was not at fault and decided against taking any disciplinary action against the police officer. Josh intends to have the decision of the Commissioner of Police reviewed and has come to you for advice. He wants to know if he can file an application for review to the Administrative Appeals Tribunal. What would you tell him?
Okay, thank you, Vivian.
You're welcome.
What do you think?
Well, I will tell him he has the option of, yes, he can file his application for review. He has the option of a merit review or a de novo review.
Okay. Comments from the others? Anthea?
Sorry, man, Joe, I haven't done this question or any of the other questions, so yeah, I apologize.
That's all right, but I'm glad you're here, Anthea. I'm glad. Others, Edward or Amelia? Edward, yes.
I thought you need to check, does the enactment provide for review by the tribunal?
Yes. So Edward is correct. Before we can tell that the Administrative Appeals Tribunal has jurisdiction over this decision, there are two things. There are two crucial things that need to be established. One is that the decision, the administrative decision, was based on a particular enactment. And two, that the enactment provides that an application for review can be made before the Administrative Appeals Tribunal. So at this point, we don't have those facts. We can make an assumption. It depends on the assumptions. If we can make an assumption that this was based on an enactment and that specific enactment provides that an application for review of the administrative decision can be made to the Administrative Appeals Tribunal, then the AAT would have jurisdiction. But if the administrative decision was not based on an enactment, it could be that the commissioner of police relied on its inherent disciplinary powers, and in that particular case, it might be based on certain regulations that do not provide for a review by the Administrative Appeals Tribunal. Then, in that case, the AAT will not have jurisdiction. So it is crucial for two things to happen, apart from the question about legal standing. One, that the administrative decision is based on an enactment, and two, the enactment must provide for an application of review to be available before the Administrative Appeals Tribunal. Now, if that is so, how would you distinguish this from judicial review? So assuming that, let's assume that an administrative decision was made, and that enactment on which the administrative decision was made does not provide for recourse to the Administrative Appeals Tribunal. The question is it possible for Josh MacArthur, who suffered injuries, to then seek judicial review of the administrative decision? So let me repeat the question. Assuming that the enactment does not provide for an application for review to be made to the Administrative Appeals Tribunal, would it be possible for Josh MacArthur to seek judicial review? If you were the solicitor, what would you tell Josh? Vivian?
Yes, I think he can seek he can apply for judicial review because he has standing.
Okay.
Because he was directly affected. He has interest in the whole matter. Okay.
Now, so let's just clarify there, Vivian, as far as judicial review is concerned. So we know that as far as the jurisdiction of the AAT is concerned, it is necessary that the enactment must provide that an application for review is a remedy that is available before the Administrative Appeals Tribunal. In relation to judicial review, is it necessary for an enactment that was the basis for an administrative decision to actually provide that judicial review is possible? Is that necessary?
Yes, it is.
So if the enactment is silent about recourse to judicial review, does it mean that judicial review is unavailable?
I don't know.
What do the others think? If you can say something.
I don't. So if it's for just judicial review, I don't think the enactment has to specifically say that judicial review is possible.
Very good. So that's correct. So the difference is, as far as judicial review is concerned, for example, as far as the Administrative Decisions Judicial Review Act of 1977 Commonwealth is concerned, the only requirement there is that the administrative decision is based on an enactment. There is no requirement that the enactment itself must provide for judicial review. Judicial review is inherent either under the ADJR Act or as part of common law judicial review. There is no requirement. The AAT Act, however, provides that the AAT only has jurisdiction in relation to those administrative decisions where the enactment on which the administrative decision had been made also provides that an application for review could be made to the Administrative Appeals Tribunal. Okay, so we make that distinction. Now, so having clarified that, assuming that an application for review to the Administrative Appeals Tribunal is not available because the enactment that had been the basis for the decision of the Commissioner of Police does not provide for recourse to the Administrative Appeals Tribunal. Let's assume that. Okay, so the enactment does not provide for an application for review to the Administrative Appeals Tribunal. Josh MacArthur now asks you if he ought to apply for judicial review. How would you answer Josh MacArthur in that instance?
can't you only review a decision based on a question of fact or law?
Go on, Anthea. Yes, go on.
So if he wanted to go to the next level of judicial review, he has to find something in the previous decision that the Administrative Appeals Tribunal, they've had a fault there in how they've applied the facts or the law, and that's the only way to go to the next step. Okay, so let's make a clarification of the factual question I had. Let's assuming that it's not available. Okay, so we're making the assumption that Josh cannot go to the AAT because the enactment on which the decision by the Commissioner of Police had been made. Let's assume that that enactment does not provide for recourse to the AAT. So the question now is, can Josh apply for judicial review? That's really the question there. Can he seek judicial review, assuming that recourse to the AAT is not available? And how likely is it for judicial review to prosper? Well, I just heard the question again. Maybe not, because it's an actual investigation in regards to an officer. So, okay. Yeah. Okay. I don't know if I've answered that correctly, but
you're actually correct. But I'd like an elaboration. Go on. You're actually correct. So what do the others think? Others, what do you think? Edward? You want to give
sorry, I don't know.
Sorry?
Sorry, I don't know about this one.
Okay, so in this particular case, it can be argued that recourse to judicial review is possible because there has been an enactment. I mean, there has been an administrative decision that is based on an enactment. So potentially, judicial review is available. There are, however, two problems. And this would be the reasons why, if you were a solicitor, you would advise against filing an application for judicial review. The first problem is that if you examine the decision of the Commissioner of Police, it actually involves a determination as to facts. So in this case, the Commissioner of Police felt that it wasn't the police officer who caused the injuries. That is a factual question. If you seek judicial review is limited to a determination of questions of law, not questions of fact. So if you cannot argue or raise a question of legality, then judicial review is likely to fail. Unlike merits review, where the Administrative Appeals Tribunal can examine the merits or the factual correctness of a decision, if you speak of a judicial review is limited to a determination of legal questions, not the factual question. So that's problem one. What can be the second potential problem? If, assuming that you were able to overcome the problem about a factual question or a legal question. So let's assume that the question is actually a legal question, and therefore it is something that could properly be before a court. But what is the other problem there? If you were to apply for judicial review, and to contrast that with the powers of an administrative tribunal, what is the second limitation of judicial review?
I think the second limitation can be, it can take a long time.
Okay.
And it can be expensive. It might be expensive. There may be a lot of delays, hurdles, and maybe a slow process.
That's right. So from a technical viewpoint, that is correct. The problem really is that if you go to the court, that can be very expensive. You need lawyers for that, and it's going to take a long time. Had this been litigated before the Administrative Appeals Tribunal, it would likely have been inexpensive. It would have been less formal. You probably don't need a lawyer. And the proceeding is likely going to be more expeditious, faster. So that's fine. But what's the other limitation of judicial review in terms of the powers of the courts concerning judicial review?
So the court can't change the decision which has been made. They can just say whether it was correctly made or not.
That's right. So that is, thank you, Edward. So that is the problem, the other constraint of judicial review. Judicial review is a very limited review, and it has there is very limited scope as far as the exercise of judicial powers are concerned. So the court can either affirm the decision, or it can remit the decision back to the original decision maker, but it cannot substitute its own judgment. So the courts don't have that power. It cannot remake the decision of the original decision maker. Unlike a merits review process, the administrative tribunal can substitute its own decision for that of the original decision maker. So ultimately, therefore, if you are a lawyer advising a client as to whether or not to pursue a merits review or a judicial review, you need to ask about the potential remedies. Are there remedies that will satisfy the interests of your client? Because if at the end of the day, the court in the first place cannot substitute its own judgment, then what is the point of going to the court? So that is the other thing you need to examine when you consider the possibility of applying for judicial review. Okay, so let's proceed to discussion question 4. Can somebody read question 4 for us?
Yes.
Okay, I'll go ahead.
Thank you.
Kim Upshot operates a car rental business and has been doing most of the business accounting tasks on her own. An audit by the Australian Taxation Office, ATO, revealed that Kim had misinterpreted key provisions of the Australian tax laws and as a result was deficient in the payment of taxes in the amount of $4,965. She asked the ATO to review her tax liabilities. The ATO affirmed its decision and reiterated the reasons for her tax liabilities. She was advised by the ATO, however, that the relevant laws allowed her to have the ATO decision reviewed by the Administrative Appeals Tribunal, AAT. Kim then sought legal advice to determine the next step she should take. A tax lawyer was of the view that a proper interpretation of the relevant tax laws and certain factual matters not brought to the attention before the ATO would show that Kim only owed $2,464. At the tribunal, Kim included in the statement of reasons for her application that the ATO interpretation was wrong and that it had failed to consider certain factual matters that would have caused a reduction of her tax liabilities to $2,464. The ATO argued that it was not open to Kim to raise these new matters, as they had not been brought before the ATO. It argued further that the tribunal's power of review was limited to the matters and reasons cited in the ATO decision. Who is correct and why?
Thank you, Anthea. Can somebody try to answer that question? Vivian?
Yes. I think the ATO is wrong, and because the administrative tribunal's power of review is not limited as such, because in this case it encompasses taxation matters and other. It has a wide scope of operation, which includes taxation matters.
Okay. Now, how about this argument by the ATO that there are certain factual matters that seem to have been raised for the first time before the AAT, And that the argument, therefore, of the ATO is that the AAT can only consider those matters or even those arguments that had been brought before it or before the original decision maker, which was the ATO. How would you respond to that?
Well, there's also for the administrative tribunal, they also deal with evidence.
Mm-hmm.
They deal with evidence. They deal with facts,
Mm-hmm.
evidence. Yes. So.
Okay.
So yes.
So what actually, so Vivian, you're correct. So what actually happens is that as far as the AAT is concerned, it conducts a trial de novo or a hearing de novo from the very beginning, and it stands in the shoes of the original decision maker. So the AAT actually has the jurisdiction to examine new matters, new evidence, new arguments brought before it for the first time, because it acts and puts itself in the shoes of the original decision maker. So even if there had been evidentiary matters or even legal arguments that had not been raised before the ATO, it is within the jurisdiction of the AAT to consider and take into account of these matters in arriving at a decision. Okay, so we seem to be quite quick. It's 7:54. We've got 20 minutes to go. Would you happen? I've run out of the tutorial questions. We've covered them all. Would there be any questions you'd like to ask? Or could somebody, or you want to raise, or could somebody try to provide a contrast between merits review and judicial review?
Sorry, could I just ask a question about the assessment, which is due next week?
Yes.
So I was just having a look at the guidelines for the Australian legal citation system, because that's the first time I've come across that, and it just seems quite complicated. And I just wondered, sort of how much should we be concerned about that, and do you think it's a big issue in terms of the essay?
Okay, so first of all, it's focus on the substance. I mean, if you've got limited time, focus on the substance, the introduction, the issues and the arguments you're making, and the legal research. The citation, though, is crucial for two reasons. There are two aspects of the citation. One is whether or not there are, in fact, citations. That's one. So in other words, if you have a legal research essay and there is no citation, what it essentially really means is that all your statements are not backed by what might appear to be the law. You are just making a statement from your own personal viewpoint, and that is likely to be of limited value. So one is, do you have any citations? Meaning, do you have any references to back up your statements, your arguments, or what you think is the law? So that's crucial. So if you don't have that, it weakens your essay. So that's one. But the second aspect is, assuming that you do have references, you do have the citations, the question is, are you citing, are you properly citing your sources according to the guidelines of the Australian Guide to Legal Citations, the 3rd edition? That's the second component. Now, it is likely the case, I can't remember the details now, but in terms of the marking criteria, I think the format of the research essay comprises 10% of the grade for that assessment, the format. The format has several components. Not only does it relate to the way it was written, meaning, in other words, grammar, proofreading, spellings, margins, and so on, it also takes into account the question of proper referencing according to the AGLC. So in a worst case scenario, that somehow, because you ran out of time, or perhaps you couldn't be bothered, you didn't really follow the AGLC, it will not mean that you will end up with a 0 for format, but there will be deductions. It could be 1 point, it could be 2 points. So the failure to follow AGLC will mean that you will not get the full 10%. If I think it was 10% for the formatting there. Now, I don't think, in all likelihood, Edward, I'm not sure if you'll have so many citations in your research essay. I don't think it really takes that much time. So it will be a good thing for you to become a bit more familiar with the use of AGLC, because that skill is something that you will need as you move on in your law degree.
Okay. Right, yeah, no, so the reason I haven't come across that before is because I'm actually just doing a few modules because I'm a UK lawyer requalifying in Australia. So I'm not doing the full law degree, and so I just started 3 modules this term.
Interesting. So you are a lawyer in the UK. Well,
Yeah.
Okay.
So that's why it's all a bit new to me, but yeah, thank you.
Okay.
And my other question was about footnotes.
Yes.
In the essay. Will you be expecting us to use footnotes, and if so, how much sort of substance would be in those? Because I can see they're not included in the word limit, are they? So I'm assuming you don't want anything that's relevant in terms of discussion or commentary to go in the footnotes if we want to.
Did I hear you? Did I hear you mention something about endnotes, Edward?
So footnotes
And endnotes. Endnotes.
Oh yeah, is that a different thing?
That's a different thing. So endnotes are pertaining to the MLA or the APA or the Harvard style. So that means that after you make a statement, you have an endnote within the text. In law schools, we don't use endnotes. Instead, we use footnotes. So footnotes are the ones where you end up putting a number to reference something that you've actually used a source as a citation. So the footnotes go in the foot of the notes. So as far as citation practices are concerned, in relation to law assessments, we don't have endnotes, we only have footnotes, and the footnotes have to be according to the AGLC. Did that answer your question?
Yeah, but no, I'm just wondering, like, how much detail do you want to be in the footnotes? Because if it's just referring to where we've got that quote from, for example, that's one thing. But then I can see from just looking at the guide that sometimes in a footnote you might have explanation in there.
True, that's true. So that's right. In fact, if you do look at academic journals which use footnotes, it is often in footnotes where there is an elaboration of a concept, especially if that concept, if it were to be used as part of the discussion, can end up making things off tangent. So let's say a question such as separation of powers has been raised, but to explain the separation of powers will end up becoming more of a digression from a key argument you're making in the body. So what they do is to provide a discussion of a concept in the footnotes. So in relation to your question, therefore, as far as the footnotes are concerned, what it essentially means is that we focus more on the citation, meaning what is your source? And if you've cited your source, you must then cite that source according to the AGLC 3rd edition. Now, as to the second question, is it necessary for you to expound on certain concepts that are in the body of the paper? Ultimately, it really depends on you. And I'm not sure if in the guidelines I indicated that that you're actually permitted to elaborate on certain concepts, and that will not be counted in the footnotes to an extent. Okay, but we avoid instances where you actually have 1,000 words in the body, and then you have another 1,000 words in the footnotes. That will not be permissible. So we're talking here of what might appear to be reasonable. If you feel like you need to elaborate on certain concepts, and it would then make you go beyond the word count, then you could have some discussion in the footnotes to elaborate or provide further explanation about certain concepts. But certainly, what you want to avoid is to have 2 essays, one in the body and then another essay in the footnote, because you're then developing another sort of arguments there. So there should be a limited discussion, if need be, in the footnotes, although I would find that unusual.
Okay, no, that's fine. So yeah, so basically, I'm just going to limit the footnotes to just the references for the
Yes.
quote. I'm not going to put any discussion in that.
Yeah, because remember, this is just a 1,000 word count essay. This isn't meant to be an extended essay. So, and I don't want to be reading a very long essay. That's why it's just a 1,000 word count. There is a second assessment that we have that will require a longer word count. But for this one, you need to limit your discussion to 1,000 words.
Okay. And also another question. Do you, I know it says we have to refer to a few sources in preparing this essay. So do you think we can get all the information we need from the textbook and the notes? We don't need to be looking sort of directly at other textbooks or cases that aren't referred to in the textbook.
I would think that. Where's that? There's an echo there somewhere. I'm gonna have to mute you a while. Okay. There. Then you just unmute yourself, Edward, at some point. So, depending on the topic, it may be necessary for you to actually go beyond and outside of the textbook, depending on the topic. There is no need. It's possible that the topic you're trying to write on can be fully answered by just using the textbook and the references within the textbook. But I would think that there are certain topics there, the ones that are among the ones that I suggested, where you will likely need to do further legal research by providing citations and sources that are not within the textbook.
Okay, thanks. I was thinking of doing the first option, which I think was something like discuss the role and importance of administrative law. Yes, and I noticed that's probably the most kind of broad and vague question of all of them. Would you say that's easier or more challenging to take a more sort of broad question like that?
I think it shouldn't be that difficult. The advantage is it makes you examine the importance of taking up administrative law in the first place. So if you're able then to come up with an argument or examine that particular question, the role and importance of administrative law, then you try to finish the course, the unit that we have of administrative law, having an appreciation of its value. Now, given the fact that it is broad, and given the fact that there is a strict word limit of 1,000 words, what it does mean is that you need to be able to focus on a key issue and a key argument. So when you talk about the role and importance of administrative law, importance in relation to what? Is it, for example, in relation to administrative justice? Is it in relation to the separation of powers principle? Is it in relation to providing an expeditious way by which people aggrieved by an executive decision can then find a legal recourse or a legal remedy for the review of the decision? So the important thing there is that in dealing with a broad topic, such as the first one, you need to focus on a key issue and then make just one argument. You can't be coming up with, you can't be talking about 2 or 3 legal issues or 2 or 3 arguments there. There's not enough word count. Just focus on one.
Okay, yeah, that's really useful. Thanks. So you can take a broad topic, but then as long as you focus it down on one sort of sub issue.
You need to. You obviously have to focus on one key issue there. So you could say in your introduction that there are many ways. It has been said, for example, that the value of administrative law can be along these areas. In this particular essay, I focus on this particular role and importance of administrative law. So that's part of your introduction.
Okay, thank you.
From Amelia, so the rubric, I'll put it up by tomorrow. I forgot to put it up. So I'll put up the rubric for the assessment. So for those of you who are asking, what's the difference between the rubric and the marking criteria? So the marking criteria are those which identify the broad outlines of how the markings will be done. Like there'll be perhaps 10% for issue, 20% for identification of the law, and then maybe 30% for the arguments. I can't remember what the marking criteria were. The marking rubric actually provides detailed explanations for each of the marking criteria. So how, for example, will a paper be marked according to legal issue? And then we make a distinction between a high distinction answer and a failing answer. So those rubrics provide descriptives or descriptions, detailed descriptions of what comprises an excellent answer as opposed to a poor answer. So that's what the marking rubric does. I will post it tomorrow. I had forgotten to post it, but I will do that tomorrow. Okay, welcome, Ernest. Thanks for joining us, even if you know, it was a bit late. At least there are 5 of you now. Thanks for joining. Any other questions? And so, as I said, if you happen to have any questions about the assessments, please feel free to send me an email. In fact, my concern is that there doesn't seem to be a lot of engagement going on, and I'm bothered by that. I'm hoping that, you know, some of you will start sending me more emails, so that you know that I'm around, and it's not as if, you know, I'm a very distant lecturer for you. Okay.
Hi, Manjo.
Yes, Anthea.
It's Anthea. I just wanted to ask a question because I've chosen my topic.
Yes.
And it's about what the role and importance of admin law.
Yes.
I just wanted to know, what is actually the difference between the role and the importance? Like, I kind of got confused because I can put, like I can have the role like to regulate and control the government.
Yeah.
And then the importance of that, well, is that like to ensure that people's rights are not affected?
So let's take an example. The role of administrative law in the separation of powers. So the role there, what's the role of administrative law in the separation of powers? It could be argued that as far as administrative decisions are concerned, prior to the emergence of administrative law, typically administrative decisions had to be reviewed by the courts. So that is the role.
Okay.
So therefore, administrative law has a new role now because it provides a new legal avenue for executive decisions to be reviewed, not by the courts, but by an administrative tribunal, which examines not the legality, but examines the factual correctness of a decision, for example. Because remember, you know, factual aspects of a decision are beyond the purview of judicial review. So that is the role of administrative law in relation to the separation of powers. The question is, why is that important? That is important, one, because, as we said, what would have been, so if there had been a factual question, that couldn't have been reviewed in a judicial review. That's why it's important. So it provides a new legal avenue. Two, it's important because it then provides an inexpensive, an informal and expeditious process by which a review of administrative decision can be undertaken. That is important, right? Because it provides greater access to justice for ordinary citizens who initially might have been prevented from seeking a review of an administrative decision because of the costs of having a court litigation or their unfamiliarity with the law. So can you see the difference between the role? So after you've identified the role, a specific component of or a specific aspect of administrative law, you then try to tease out the importance of administrative law in relation to some principle that you've identified.
Okay, so you're saying that, like, for example, the role, there's many roles in regards to administrative law, and we can just pick one and then answer why is that important.
Yes.
And go into some depth in that.
Yes, that's right.
Okay.
Because administrative law can have a role in terms of, in relation to democracy.
Yep.
It can have a role in relation to access to justice, separation of powers, as we mentioned. I think something about, I can't remember what Edward talked about in relation to the role of administrative law. But I mean, certainly, administrative law has several roles in society. You identify what they are. Once you've identified that specific role, why then is that role important? It's one thing to talk about the role, but why is it important? So you can talk about the role of separation of powers in a democracy, but why is it important? So that is a different argument you're making there. But what is crucial is that you need to limit your discussion. to one key issue or key argument, because you don't really have the luxury
word limit.
because of the word limit.
Yeah.
From Vivian again, is the AAT a form of alternative dispute resolution? The answer is no. Because, again, and this isn't my area, so I'm not going to go into civil procedure, but typically when you speak of alternative dispute resolution, it can be before a court or it can be before a tribunal. But essentially what it means is that there is an attempt on the part of the parties to arrive at a agreeable solution that they try to forge between them. That is not the case with the AAT, because the AAT is a tribunal that makes a decision. Certainly, it will allow the parties to try to discuss matters, and that is part of the expeditious and the informal process. But it is not certainly not it is not limited to resolving a dispute on the basis of what the parties can agree on. It does make a determination, regardless of what the parties say. Okay, it's now 8:14. Any other questions before we end tonight's session?
I've got another one.
Yes, go ahead.
In regards to the role, would you look at administrative values and principles?
That's also possible.
Okay.
It's really open-ended. So at the end of the day, I'm giving students an opportunity to think more closely about administrative law and then focus on specific topics that they may want to explore further, just as a way of, as an introductory way of getting more engaged with the course or the unit.
All right then. Thank you so much for that, Manjo.
Anything else?
No, not from me.
Okay then. So thank you very much for joining tonight's session. And I wonder if we're meant to have a drop-in session next week. I can't remember. But in the event you might happen to have any questions about the assessment or any topic about administrative law, please do not hesitate to send me an email. I'd be more than happy to answer you. Or post your question in Moodle, and I'll answer it. I'll try to answer it within 24 hours. Weekends being exempted. Okay. Thank you very much, Edward, Amelia, Anthea, Vivian, Ernest, for joining tonight's session, and I hope to see you again next week. And remember, next week is the deadline for the research essay. Thank you. Good night. Bye.